Good evening, everyone, and welcome to another edition of our Justice and Pieces guest speaker series. We are here back in 2024 for season five, and I can't believe it's been so long since we started during the pandemic. I thought it would be a couple of things to do for my students. We'll be back in school a week later, and here we are, 4 years later, still going strong, and with many more guests in store for you this year. And kicking us off today, I'm really happy to be joined by Christine Hickey. Christine, perhaps maybe, first of all, welcome, and perhaps maybe you can tell us a
Thank
little bit
you.
about yourself and the practice that you have.
Great. Thanks, JP. It's a real pleasure to be here. I am a licensed paralegal. I obtained my license in May of 2023, and that is after about 20 years of experience in the legal field. I trained as a paralegal back in British Columbia in the late 90s, early 2000s. But in British Columbia, there's no regulatory body for paralegals. So we function akin to a law clerk here in Ontario, where you work under the supervision of a lawyer. So I did that, worked in civil litigation, quite a variety of areas: personal injury, insurance defense, employment, construction, commercial litigation for about 15 years, 12 to 15 years. And then I shifted to professional regulation and worked at the College of Physicians and Surgeons in BC until I moved here to Toronto in the summer of 2018, at which time I decided to pursue a master's degree, a master's in law in the area of administrative law, and then thought, well, I'm in school, so let's keep going, and applied to the Humber College graduate certificate program. So that was a one-year program that allowed me to obtain the Ontario education I needed in order to be qualified to write the LSO licensing exam. And then in July of this past year, I decided to open up my own practice, and that's been an interesting journey over the last 8 months.
Now, Christine, you mentioned BC, and I don't know maybe if you're any familiar with it, but I know the last I was chatting with some people out there in the summer, there was a direction towards getting licensing or some kind of under the law society in BC with paralegals there. So maybe you could tell us a bit about kind of from your time there, in working in that non-regulated roles that you were having. That is it time other provinces or Alberta, I think, as well, looking at things where we have a structure here in Ontario, or I mean any insight you can share from your time in BC that people from Ontario might not be aware of what happens
Sure.
out there.
Yeah, no, it's a really interesting process. And the Law Society's honestly been discussing the matter of regulating paralegals for over 30 years. It comes up and it goes away, and it comes up and it goes away. And they haven't ever quite committed to taking that on. Yeah, my understanding in the time frame since I left BC almost 6 years ago now, that the push to regulation is a lot stronger than it's ever been before. There was, in my time there, a pilot project where they allowed you could be designated as a paralegal who could appear in uncontested family matters. So they had like a little pilot project to see how that went. My understanding, it went pretty well, but then it didn't really go anywhere after that. And then they introduced a thing which is called the designated paralegal, but you still were working under the supervision of a lawyer who then attested to your skill and knowledge, and would indicate on their annual renewal that you were supervising the work of a specific paralegal. And then that paralegal could use this title, designated paralegal, and that would give them a little bit broader scope. You could provide undertakings, you could give some legal advice in the area where you're working in and designated, and you could appear before tribunals with that tribunal's authority or their permission, I guess I should say. So for myself, I was a designated paralegal in the professional regulation world, with the College of Physicians and Surgeons, and that gave me the opportunity to appear before their third party tribunal, which is called the Health Professions Appeal Board. Here in Ontario, it's called the Health Professions Appeal and Repeat Health Professions Review and Appeal Board, HPARB. And on BC, it's called the HPRB. And so I was able to do that because in BC, under that regime, when you're dealing with complaints to a professional regulator in the health professions, the college is a party to those proceedings. So that's not the case here, and I'm happy to go into that a little bit later when I discuss some of the areas of practice in.
Yeah, perfect. So I mean, maybe that's a good time. You could tell us a little bit. You opened up your practice late last year. What's that been like? What areas are you doing, and anything you can share for students that are going through, they get licensed, right? I have some students that just got their license. They passed the exam in November. They got wind of it late December. They got through all the paperwork last month, and
Mm-hmm.
now they're like ready to go, and they're looking for
Right,
what do I do next, right? I mean,
right.
everything else was school, this, I checked all the boxes, and
Yeah,
now I'm a licensed paralegal. What's next? So maybe you can tell us a little bit about that decision. I think from after writing your licensing exam and to getting your business up and running.
sure. Um, it's certainly a decision I didn't take lightly. I knew building my own business was going to be a challenge. But I felt fairly comfortable given my extensive experience that I had a solid understanding of basic tort contract principles, so I could take on small claims work, and as well with a focus to building a client base that is in the realm of professional regulation. So to start my business, I worked on a business plan. I did some research in terms of what, if any, other paralegals are working in the realm of professional regulation, because that's really where I wanted my niche market to be. I think that's a really important thing if you're wanting to build a business and have it be successful and unique, is to just find that niche thing that makes you stand out a little bit. And I got some or practice management software and learned how to use that. I got an accountant to do some books for me because that is not my strength. And then I started networking, and I'd have to say for most people just finishing with their license, whether you have an interest in wanting to be a small business owner, an entrepreneurial spirit, or you're looking to join an existing firm, whether that is a paralegal or a bigger firm as a law clerk to begin with, that sort of thing. Networking is really critical, and do as much of it as you can. Go, and I know for myself, it was really outside of my comfort zone. I never considered myself much of a salesperson or somebody comfortable selling myself to someone else and what my skill set is. So I built myself a little elevator pitch, and I went to everything. And basically to myself, it was said, you can't say no to any of these invitations, these opportunities. And it was awful at first. They were really nervous, hardly spoke to anybody. But the nice thing is, oftentimes you start to see familiar faces at events. And then soon it just became still uncomfortable. But I was able to find that way to get into a conversation, to approach people and introduce myself and ask them, what they're doing, and start a conversation from that point. And I think that's been one of my biggest benefits and the biggest boost to my business, really, is just getting to know people in the profession. And I've been so pleasantly surprised at how generous people are when you approach them, and offer their assistance and offer to provide you with mentorship. I've just been really lucky in that respect. The other thing I did was I joined a specific networking group called the Entrepreneur Nation. They have multiple chapters throughout kind of the lower the GTA and I guess beyond as well. Um, and that's been a really beneficial in, network to join for me. We meet once a month for about an hour, usually over lunch. And I've just met such a variety of people, and the idea is to build this network of people that you get to know and you trust, and um, you are there to help build up each other and build up each other's businesses because everybody else is in kind of the same position as you are, where they have either a small business or a moderately, you know, mid-sized business, and they're just looking to continue to build their client base as well. And so it's a lot of sharing ideas about how you can do that, um, and just specifically asking, you know, this is the type of client base I am interested in building. Can you help me with that? And so if you have an opportunity to join something like that, some networking group, I strongly recommend that you do that because it's really, networking is critical to building a business.
Perfect, and certainly it's a very integral piece, right? It's not about just necessarily learning the law and being good at it, but you know who's going to be knocking on the door, coming to you for advice. If you know if there's nobody coming, then it kind of makes it
Yeah,
difficult to practice.
that's right. Exactly. And it's just the other thing too is you get a client that comes to you and they bring you a problem, their legal problem that, you know, you can handle the bulk of it, but there's like a little bit like you need an ear, you need someone to bounce some ideas off of. So having a network of people that either in the business world or in the finance world or in the law, the legal world as well, that you could call and be like, I don't really know much about this specific point. Can you give me some information about that? And that will help you be able to provide your client with the best possible service.
Yeah, and certainly you brought up the entrepreneurship, and I think people don't realize, or maybe sometimes paralegals and newly licensed lawyers don't necessarily realize that there's such an interconnection between people, right? That somebody might come to you for an immigration issue, and then later, once they've immigrated to the country or they've solved that issue, then now they have an issue with their landlord, and then from there
Right.
they need to get a mortgage, or you know, and then it all kind of
Exactly.
goes and they're all interconnected. So people don't realize, well,
Right.
hey, how is this person going to help me? But
Yeah.
you don't realize, you know, all of the bundle of services and all these excellent professionals that you encounter. I mean, you don't know where it's going to come from, and then you know you pay it back and it you know it comes back to you
Yeah.
triple.
Exactly. Yeah. No, I fully agree. It's just one of the things I found to be the most important part of building my business is getting to know people and starting to build a relationship with them and develop that level of trust and comfort with someone. So yeah, step outside your comfort zone. It'll be worth it.
Yeah, now let's talk more a bit about you know your practice and certainly the areas you're looking at growing, and then perhaps maybe you could tell us kind of what you know comes through the door. What are those problems you were saying that you know clients come to you with, and maybe we can kind of go through that.
Sure, absolutely. Right now, I am trying because I have quite a bit of experience in a variety of different areas. I feel comfortable taking on some files that maybe a newer paralegal might not feel so comfortable with. So I've taken on, you know, a variety of different small claims matters. The bulk of those are actually been contract based. So um, individuals like homeowners who have retained a contractor to do work in their home and then that's gone sideways. And now the you know the contractor took money and disappeared or did a really terrible job of the work, um, or it's a subcontractor trying to get paid some invoices from the main contractor on a job. So that's been an interesting thing in terms of my small claims work is just the number of times that you see people who just verbally make a contract and sign it with a handshake and how troublesome that can be in terms of like, oh, that's a decent person. Well, I trust them. But, when things go sideways, not having a contract on paper is really a challenging point. So that's been keeping me busy, those types of files. And it feels very satisfying to help, a homeowner, and another small business subcontractor, um, you know, get the justice they deserve in terms of not being taken for a ride by someone, or having to live in a house that's full of deficiencies, and they're going to have to even spend more money to fix those. So that's quite interesting. I have a few, little handful of landlord tenant board matters. Um, Landlord tenant board residential tenancy stuff is quite technical. So if something comes to me that's a bit more involved, I tend to refer that to another paralegal who I know that is very well versed. Like that's all they do is landlord tenant work. But if it's something a little bit more straightforward, I take that on. Um, but again, not really the area of practice I'm focused on building. But I think it's beneficial to have a little bit of knowledge in that area, and to be able to answer some questions. It's such a huge area of practice for paralegals is landlord tenant board matters. Um, that ideally I have a couple of professional regulation files, and that's really where I would like to build my business. And those files deal with a licensed professional in the health world, in the health regulation health industry. And the client has received a complaint from their regulatory body, indicating that a member of the public, whether it be a patient or a patient's family member, has filed a complaint about whether it be their conduct or their clinical skills, with their regulatory body. And then they are seeking my assistance in how to navigate that process and to respond to their regulatory body in a timely fashion, and in a way that's not going to create more problems for them down the road. So I have that's the last 12 years of work I did prior to opening my business was in professional regulation. I find it really interesting. Like admin law to me is just really fascinating area. And so it's, yeah, those are interesting files. And um, yeah, would you want me to give you a little overview of how that process works, JP?
Yeah, I think that'd be great. I mean, I'm teaching tribunals right now, and certainly we know a lot of the focus. We go through like the Human Rights Tribunal. We look at the WSIAT, and unless a student, they do these group projects where they can pick a different tribunal and kind of
Right.
observe, and then do a kind of detailed report as a group, and present essentially to the class, so they learn about some other areas. But
Yeah.
again, a lot of these professional discipline panels, other than the Law Society Tribunal, which we do cover, and there's many of them.
Mm-hmm.
Maybe you can kind of walk us to, how it starts initially. So, what happens in terms of, a complaint, and whichever, I know there's a few different ones, but whichever one,
Yeah.
I know sometimes they're very similar, but sometimes they're pretty
Yeah.
different too. But kind of what's the first step in how the practitioner gets wind of a potential disciplinary hearing?
Certainly. Yeah. So mm, the what I'm going to discuss really focuses on healthcare professionals, but it's a very similar process across the board for any licensed professional in terms of just the principles of natural justice and procedural fairness apply kind of across, I think, almost entirely all regulatory bodies, professional regulatory bodies. So the first step is the regulatory body would receive the complaint from the patient or member of the public. Um, and then that complaint is reviewed, determined whether there's a conduct, clinical component or a conduct component to it, essentially. And then the complaint is, uh, well, some regulars do a little bit of investigation at that point. Try to pull together. They talk to the complainant. they get a little bit more information about what the complaint is about. And then the complaint is given to the regulated professional to respond to. And so it's just provided usually via letter with a cover letter attached and a time frame set. There's a request made for all clinical records that relate to that patient, or if it's a family member, then obviously what relates to the patient that the family member's concerned about. So that's a really important step once a regulated professional receives that complaint, because the way they respond to it can have a really significant impact on how the rest of the proceedings are going to go. From my experience, most regulatory bodies, they have an initial screening committee that will look at the response and the records and determine if there's a potential for this matter to be a breach of professional standards, and which would then require a referral to discipline. So complaints don't go automatically to the discipline committee. They're reviewed by, especially in the health world, they're reviewed by a committee called here in Ontario, the ICRC, and that's called the Inquiry, Complaints and Reports Committee. And so they're kind of the gatekeepers. They determine what has the potential for professional misconduct and refer that on to more substantive investigations and onto a discipline panel. But prior to that, the response that professional gives is really important. And I've seen this more recently, actually, in a matter I'm working on before the Law Society Tribunal. And what a committee wants to really see is that individual has spent some time thinking about this complaint and then respond honestly with candor, and the response shows that they have some insight into this complaint. And that's particularly true of complaints that have more of a conduct-based nature to them. So many people, healthcare professionals, receive complaints that are communication-based, where there was a breakdown in communication between the complainant and the patient. And so the healthcare professional indicating that they see where that happened, how they can improve upon their communication skills, taking some proactive steps to do some reading or obtain a little bit of additional education around those things can really go far in terms of how the ICRC committee will handle that complaint going forward. So those are, I think, really important things. If you're working with a professional regulator, if you're representing professionals that are before the regulatory body, is to have that conversation with them and really ensure they understand the importance of that honesty, the candor, and the insight into this complaint, and respond accordingly. Responses where there's little bits of information given here and there, or your finger point back to the patient, that doesn't do you any service in terms of your complaint with your regulatory body. So once the complaint and your clinical records have been delivered, the complaint response, and the clinical records have been returned to the college or the regulatory body. In some cases, in most cases, that response will be given to the complainant. Depending on who the complainant is, the medical records may or may not be disclosed, or they may be disclosed but highly redacted. Lots of critical or personal information regarding that patient will be removed. And then the matter is prepared with all the material that the investigators have received, and it'll go for review by the ICRC. And at that time, the ICRC has kind of three levels, like that they tend to kind of look at. Does this fall into a level of not really any concern, or there's no substantiated complaint here? And that comes from a review of the medical records, the response that the um, healthcare professional has made. Then there's kind of the mid range, like, okay, well, this, there might be not a full understanding of the standards of practice here. And so maybe this person needs some remedial education, or they need a little bit of a reminder of what their professional obligations are. But it's not to the point where they need anything further than that. And so the ICRC has the ability to respond to, provide direction, provide or require the healthcare professional to undergo additional education if that's an appropriate thing, without having to refer to a disciplinary committee. Then if the ICRC determines that the conduct or the clinical issue has really completely breached the standards of practice, that requires referral to the discipline committee, because there's a strong likelihood there'll be a finding of professional misconduct. And those don't happen. I think it's important to understand that the vast majority of complaints really are dealt with at the ICRC level. It's complaints that have a boundary violation kind of nature to them. So whether that be of a sexual nature, fraud, those sorts of things, those will almost always certainly go to a disciplinary hearing. And so that's kind of the general process. The disciplinary hearing functions a lot more like a court proceeding. There's witnesses, there's opposing counsel that you can be cross-examined, witnesses are questioned, and then the disciplinary committee makes a finding of fact and a decision in terms of what the what's going to happen to the health professional. So whether they're suspended, whether they're fined, whether they're reprimanded, which is, they have to appear before the regulatory body, and kind of be given strong advice and recommendations that strong advice and direct directions that this will not be tolerated in the future, or their license is revoked. And that's obviously the most significant thing. Disciplinary hearings function in kind of progressive steps, right? So obviously, whether or not it's your first time committing any sort of sexual boundary violation to a patient, that could almost certainly will result in a suspension. But let's say you continue to have communication problems, and you have a history of these sorts of complaints, and in and of themselves, each complaint, they don't necessarily indicate a problem, but altogether, like, okay, there's something going on with this person in terms of their ability to communicate properly with patients. And so then you have this kind of like, okay, well, this has to move on. There has to be some progressive kind of discipline here. So that can also be a way in which a healthcare professional can end up before a disciplinary hearing, whether they have a history. And that's something that the disciplinary committee will consider in its deliberations and decisions.
Perfect. So thanks for that sort of overview from kind of beginning to the disciplinary hearing process. And maybe just want to step back kind of after, it goes to the investigation stage. And again, as you mentioned, the vast majority will be dealt with there, and then only a few ones will continue on. So how do you, if your client, let's say, finds themselves in a position where, unfortunately they get wind of, the fact that it is going to the disciplinary stage, kind of what's that process like between, I guess, from that point and up to the hearing?
Well, there's a number of steps, right? So obviously the professional would be given formal notice that they've been the matter has been referred to the disciplinary committee. They have an opportunity at that point to respond. If they haven't done so at this point, they should certainly be seeking legal representation. Um, and then it becomes a matter of sitting down with the client um, on kind of this individual level and getting an understanding of what's been happening, um, where there's strengths and weaknesses in the complaint and in the matter. And similar to like prepping for a trial, right? There's opportunities to come to um, basically a consent agreement, right? Where the parties will, there's an agreed statement of facts. There is, um, you know, an agreement between uh, the college, the regulatory body, and the professional about what kind of disciplinary action will be taken. So an agreement that, okay, well, you'll be suspended for 3 months. You have to take course A, B, and C, and you might be fined a certain dollar value. Fines aren't done that often unless there's actually a case of fraud where someone's, taken money from a patient or defrauded them in some way. Um, Otherwise, it's often just the costs of the hearing and the process that they would be charged. Um, so yeah, there's witnesses, preparing witnesses for testimony, preparing your client, um, the complainant sometimes, particularly if you're in the process of um, prosecuting a complaint that has a boundary violation. Um, Oftentimes you'll get a complainant who's quite uncomfortable with this idea of having to be cross-examined. Um, and you might find yourself struggling to kind of get that complainant on side and be there to testify. Um, there's pre-hearing conferences that occur during that time as well to kind of help narrow what the issues are. And yeah, it runs very similar structure, to kind of a court, a small claims matter in a sense, if you will, um, uh, as well as that kind of trial process. There's usually counsel for the discipline committee, separate outside counsel that sits and will advise them. Um, and the other consideration oftentimes that a healthcare professional has and why they may be keen to settle the matter or come to a consent agreement is publication. You know, once you hit that disciplinary hearing stage and whatever the disciplinary step that's being taken, some of them require the college to publish that information. A consent agreement can really result in that being crafted a lot more specifically in terms of what's going to be published by that college. Um, yeah, does that give you the information you're looking for? I
Yeah,
hope
and I think I
like
guess the
I
last
went off a little. Yeah.
I guess the last piece then is, you've mentioned different work, right, at the landlord tenant board, small claims court, and
Mm-hmm.
now, before the, the discipline panel here, kind of maybe looking at advocacy, right? I mean, big question students have
Mm-hmm.
is, what it's like actually being in front of, the deputy judge in small claims court, or, an adjudicator, or a panel. And so maybe you can kind of highlight your experiences between the three, and what's different and unique, right? Because not all tribunals are the same in terms of
Right.
formalities and
Right.
processes, and what you can share kind of, from your experience with all three bodies.
Certainly. I think across the board, all three. Um, being respectful of the environment, of who the members are of the panel that will be hearing it. If you're in a tribunal setting, the judge or justice that you might be appearing in front of in a court environment, being respectful to your opposing counsel. I think obviously one of the key things is ensuring your client is well prepared and understands what every step in that process is going to be, whether you're in a one-day trial in small claims court, or you're in a 3-day hearing before a tribunal, that you take them through what that process is going to look like. And you spend a considerable amount of time preparing your client, so that it eases their mind, and takes away some of the unknowns of what it's like to be in a court environment. I think, in terms of advocacy for your client, you have to have had and continue to have a full and honest relationship with that client, so that you understand all of the things, that client understands where the weaknesses are in the case. But you're not necessarily going to focus on those, but you do understand where, okay, we're at this stage. Do we make settlement offers? Do we make some settlement attempts? Because, for whatever reason, something doesn't seem to be going kind of in your favor. And just having really good open communication with your client, I think, is the best form of advocacy that you can have, so that you can stand up there and feel comfortable arguing the position for them, and why either the penalty should be reduced, what goes in their favor if they're up before their disciplinary body. Something, for example, like a law society tribunal, good character is such a key component there. And being sure you have done all you can to reinforce the good character of that individual. I think those are all really important matters in terms of advocacy. I think obviously in front of a tribunal, you're really going to run the gamut. I've seen disciplinary tribunals at health regulatory colleges where, you have a 3-person panel from a committee, and this is their first time on that committee, and so there's an apprehension and a nervousness on their end as well. So again, just being kind of as meticulous and stepwise as possible, so that they're not flustered by the process, but they're actually able to listen to you. And again, I think that comes down to also keeping your submissions, your written oral submissions, as plain language, as straightforward as possible, in those tribunal settings, because you go often dealing with people who don't necessarily have that legal background when it's your disciplinary panel. If you're going to a tribunal that's a third-party review tribunal, for example, then it's a bit of a different story. There's a little bit more formality to it. You're dealing with people who are often lawyers, so they understand the procedures. They understand the law in more depth. And so you approach things a little bit differently in that respect, with kind of a knowledge that they have a little higher level understanding of those, the process and the law.
And so, Christine, the last thing kind of there with respect to this, what happens, if your client doesn't like the decision, right? Is there like reconsideration options? Is there like appeal options? Are you going judicial review? I know obviously out of the court, out of the
Yeah.
scope for paralegals, but what kind of happens next if the results don't go the way you expect them to or hope them to go?
Certainly, yeah. So for healthcare professionals, there is a third-party tribunal, and that, as I mentioned earlier on, that's the Health Professions Appeal and Review Board. Yeah, I think that's what it is, Health Professions Appeal and Review Board, yes. And so they're a third-party tribunal, and the complainant, so in a complaint matter, the complainant or the professional can have the decision of the committee, whether it be the ICRC or the discipline committee, reviewed. And then the review board will make a decision whether or not they won't re-look at the entirety of the facts, right? Because they'll look at the principles of administrative law in terms of, was this a reasonable decision? And does it meet some of those tests for administrative law? And then they can send the matter back to the college with directions to reconsider certain things, to conduct a new investigation, or they can endorse the decision of the disciplinary committee or the ICRC. And I think it's very similar in a lot of other professional regulations, well, where not all of them have a third party tribunal. You'd have to go to judicial review as your next step, but where you have a third party tribunal, as you know, and your tribunal students are probably learning, you have to exhaust all of those options before you're going to seek a court review. And that would be the judicial review step, where the court then looks at the decision of the third party tribunal and whether or not that was reasonable. Other tribunals, for example, like accident benefit, which is a huge area, could be a huge area of practice for paralegals. I actually see lots of job listings for that. You would go before I think it's the License Appeal Tribunal if you're denied accident benefit, or you're not put in a category that you think would be appropriate. I'm not well versed in that realm, but and so that tribunal would review the decision that is made with respect to your accident benefit. And so there's a variety of different ones that function outside and are independent from the actual regulatory body.
I just wanted to clarify because I think you had mentioned the complainant. So who are like the actual parties, right? Because is it, is the one, because I know there's obviously all the different colleges, right, that
Right.
kind of make up the ICRC and the HPARB, right, being
Yeah.
the third party. So
Yeah.
is the call like, like, I mean, maybe you can kind of give me a little bit more clarity of like if
Sure, of
someone's
course.
who's the one going and who's going to be on the other side, basically saying, the decision was correct by
Yeah.
the committee.
Right. So with respect to the Health Professions Appeal Board, it can be either the complainant, so the person who brought the complaint to the regulatory committee, a regulatory body, and say, I don't agree with this. This should have been a more substantive response from the regulatory body. It can be the registrant of that regulatory body, the member who says, this is way too much. Like, you got this wrong. And so in that sense, a party to those review applications is just the college. No, sorry, the college isn't a party to that. Let me rephrase that. It's the review board and the complainant or the registrant. So the college or the regulatory body would produce the entirety of their investigation file to the review board to look at, to determine whether that decision that the committee made was a reasonable decision. Whereas the difference there being, for example, in BC, their health professions appeal board, the college or the regulatory body is actually a party to that. So they go in and defend basically the position of the ICRC or the discipline committee and say this was reasonable for these reasons, A, B, C, and D, and refer to there. And so in that respect, in the case of BC, for example, the college could seek a judicial review of that review board's decision if they didn't agree with it, or if it was outside of the law. Yeah, so here in Ontario, it's either just the complainant and the member and the review board who are involved, and the college just produces documents. but they
Yeah,
don't make submissions or arguments
yeah,
as to the decision.
that's interesting, right? Because in
Mm,
one aspect, if a complainant is and certainly there's the counsel. I guess you can have people that are counsel to the complainant, right? That because they're now a party, right? Whereas in other professions or in BC where they're just a potential witness, so they may have counsel, if there's potentially like a civil litigation,
yeah,
ancillary matter, but they're generally not as involved. But here they're a party, so they're completely
yeah,
involved,
they're very
and
involved.
it also
Yeah,
passes
yeah,
on the cost of going forward, right? Whereas
yeah,
a college would absorb that cost if they wanted to appeal.
right.
An individual would have to keep going, and I don't know if there's costs and all
Yeah.
of that in play too, that may deter
Um,
someone seeking.
yeah. Not that often, actually. It's usually, you have a time frame in which you have to file um your request for a review with the review board. There's no filing fees associated with that. So the largest fee would really be retaining legal counsel, legal representation for to have someone assist you. Because again, it's a really technical um, process, in terms of lots of deadlines and timelines and documentation, and it's quite legal heavy. Seeking a review, there's a lot of legal principles you have to argue in terms of reasonableness, um, that the average individual, isn't aware of that legality component of it. So it can be costly in that sense, of having to have someone. I've been on many a case where the complainant has tried to represent themselves, and I think we all appreciate the challenges that self-represented individuals come, no matter what venue you're in, whether it's courts or tribunals, and the additional time that is taken up in those respects.
I'm always reminded when a senior lawyer told me the adage, if anyone represents themselves, they have a fool for a client,
Yeah.
type of thing there, because it's difficult, obviously. Um, And I always tell my students, unless you're like a auto mechanic yourself, you wouldn't go and do work on your car, if you don't know
Right.
how to do it. So
Yeah.
it is. I mean, sometimes it's also a product of the costs of everything, and I
Of
think that's
course.
certainly why
Yeah.
the paralegals are here, and hopefully to grow in other provinces.
Mm-hmm.
So with that in mind, I mean, you've had that sort of transition. You've come over from BC. You've gone back to school. You
Yeah.
finished, got yourself licensed, and you're practicing now, and all of that. Any words of wisdom for any paralegal students, right? Thinking back to your time, at Humber, and getting to where you are now. And I mean, it's a pretty quick road. But a very winding one, right? I mean,
It
a
has
long
been.
road from, if you
Yeah.
go all the way back to BC, right? But and
Yeah.
anything there in terms of, you were coming here, 6 years ago, you got into school, you got through the licensing process, you're starting your own practice. What can you share with students? Any final words of wisdom here today?
Sure. I think if you're newly licensed, you don't have a lot of experience in the legal field in terms of practice, I'd strongly recommend not starting your own practice right away, but to work with people who are experienced and get a couple years of that experience under your belt, like real life in a courtroom, dealing with clients, learning how to operate a business. There's a lot of facets to it. It can be really overwhelming. And I have a lot of experience in the legal world, but I don't have a lot of business experience. So I'm grateful. I've got some excellent people who are mentoring me, um, and that's really valuable. But I would strongly suggest you take a few years to get some experience, find that mentor. You can germinate your business ideas as you're going. Find the niche market, find the kind of clients that you want to serve, and then move into that realm. Um, I think just generally, in your academic studies, one of the most useful things I think you can do is really have a solid understanding of tort and contract principles. Really focus on learning that. It's foundational. to most of the work you would do in a small claims court, and just generally in terms of handling, answering questions for people. If you're interested in professional regulation, tribunal work, um, remember all tribunals are born of out of legislation. They're not an independent thing. They have parameters, and the body that has been created out of that legislation has to stay within those parameters. So those are some kind of key things, I would say to you, just to be cognizant of, and take on every opportunity you can. Don't say no. Network your face off. Just get out there and do it. Meet lots of people, and you'll find your comfort zone with it once you've done it a while. Good luck.
Perfect. So, Christine, thanks so much for taking the time and joining us here today. Wish you all the best. And thanks for everyone for tuning in. And we'll continue on here in 2024 with hopefully, hundreds of guests again, as we've been doing over the last 4 years. Take care, everyone.
Thank you, JP.